What is discovery stuff? This is part 3 of our video series on discovery. If you haven't seen the other videos, click below to get them sent to you. In this video, we're talking about discovery stuff. For example, documents, physical assets you want to appraise like jewelry, a car, or a boat, or anything else that's relevant to your case. In order to get this stuff, you need to understand the discovery tools that we have to use in a divorce. They're called notice to produce and subpoenas. I'm going to explain each one of them to you, why you should consider each one for your case. Let's do a basic overview of both. A notice to produce is a discovery tool that requires the other party to produce things in their possession or control. A subpoena, on the other hand, goes to a third party or an organization, and they're required to give you the items requested. Let's talk a little bit more about a notice to produce. A notice to produce is a formal legal request sent directly to the other party for inspection or production of specified items. In plain English, this means you must show everything that's been requested. For example, bank statements, credit card statements, employment information, or anything else that might be relevant. This could even include cars, jewelry, or a vacation home for inspection. A notice to produce requires that the other side signs an affidavit saying that they have fully and completely answered all the requested information. Let's talk about subpoenas. In Illinois, attorneys can send a subpoena directing a third party to produce items. The most common way to use a subpoena in a divorce case is to send it off to an institution of some kind and ask them to produce documents in return. For example, you can send a subpoena to a bank requesting all banking records that they have for the other party, including credit card statements, checking statements, savings, or any other statements of any kind that that institution might have. This is a very effective way to gather all the information you want from that institution in a quick manner. At this point, you're probably confused. You're probably thinking, which one should I do? Well, for starters, if you believe the other party is hiding something and you're not exactly sure what they have, you should do a notice to produce. For example, let's say you know that they have a bank account that you're not on, but you don't know exactly where it is. In that situation, you should do a notice to produce and force them to put everything on the table. A notice to produce could be cheaper than a subpoena because the other side is required to produce the items to you for your review, rather than you paying for multiple subpoenas to get the same information. A notice to produce also affords you a little bit more leeway and can cast a bigger net of information. Now, the drawbacks of a notice to produce is that you're heavily reliant upon the other person to participate in the civilized court system. Now, I know that it might sound funny and seem weird to you that someone doesn't want to willingly participate in the civil lawsuit, but there's plenty of people out there. If you're married to an asshole like that, I'm sorry, but it's going to cost you more time and money. You could end up going to court more if the other side tries to hide the information, they try and delay things, or come up with some other excuse. Now, let me be clear, the court will eventually force them to comply, but the added stress is something that you need to be aware of. Stay patient, we will get you through this and get you what you need. You may want to consider using a subpoena if you know where the information is and you know the other side's going to play a bunch of games. This could save you a lot of headache and save you from going back and forth to court. I know we just covered a lot in this video, and you probably are pretty confused at this point, which is completely normal. However, you now know a lot more than you did before watching this, and it's going to help you be that much more prepared to discuss these issues with your attorney when you meet. Stay tuned for our next video where we talk about questions, which are interrogatories, requests to admit, and depositions. As a reminder, if you haven't seen the other videos in this series and you want them, click the link below and we'll send them to you.